A woman in Australia was fired by her company after the company used a keystroke logger technology to track and monitor what she was doing while she was working from home. But just how far can your employer really go when tracking your movements and your activity whilst you're at work? Let's chat about it. Welcome back to the channel. So you might remember I've done lots of videos on data protection and surveillance and CCTV and all sorts of other stuff to do with data protection. This one story in particular here in unilad.com talks of this lady in Australia. Now, whilst this is in Australia and I at the outset will say that I practice in England and Wales. Practice is a bit like a doctor's surgery, means work professionally. Not practice as in piano practice, like you're not yet good enough. But in England and Wales, not Australia. But the data protection law is very broadly similar around the world. Now, how far can your employer go when they are tracking your movements online? The bottom line is, well, twofold, really. First of all, it needs to be necessary and proportionate and therefore justified. And secondly, it needs to be transparent. So if your company has CCTV inside your offices or even outside your offices, or they're using a camera on your computer or anything like that to film you, there needs to be a very open policy about what you are doing, what they are doing rather. So when they're filming, how they're filming, what they do with it, how long they keep it, all of that sort of stuff. Because even though you are an employee, it doesn't mean it's a free-for-all. There might be things in the contract that say that they will be tracking certain things and they will be monitoring certain things and your email must only be used for certain things. There was a very interesting case, actually, where two people had sold a business and they'd used the domain name of the business for their own personal emails. But once they'd sold the business, they wanted to keep access to them and restrict other people from accessing them. And the court said, well, no, it was a company email. So you can't necessarily just restrict access to them. And so there's a whole discussion about that. But coming back to the point, it needs to be proportionate, as in no more than is necessary. And there needs to be a justification for it. So why are they filming it if they are filming you? And for how long do they keep it? It needs to be necessary. It needs to be proportionate, how long they keep it for, and so on. But how far does it go? When it comes to keystroke technology, this might well be incredibly intrusive. Now, it will depend on each individual set of facts, because if it's known, for example, that the laptop is used not just for work, but for personal uses as well, which many laptops are, it may well be the case that a court would find that that is a step too far and a breach of data protection, in that it is more than is reasonably necessary for the company to track and monitor and store. Because who knows what really the company owners and directors and so on, or even other staff, are going to do with that information when they've been tracking those keystrokes. Not to mention that if they do log into emails and banks and everything else, and they are tracking the keystrokes and passwords, that could have serious data breach repercussions for that individual moving forward. So if you're in a situation, you're an employee, you should ask your employer what they keep, what they film, what they track, for what purpose, how long they keep it, where the cameras are situated. Is there any tracking software on the machines? And if so, what do they track and how long do they keep it for? You should read your contract. I'm amazed how many people don't read their contracts, whether it's an employment contract or any other kind of contract. You should read those contracts. And if there's something in it you don't like, then don't sign it. Too many employees are pushed into a position where they feel like they have to agree to a contract that is wholly one-sided. There are some cases that you should turn down a contract. Just like in business, there are times that you turn down the business if it's going to be far too onerous to you or far too far-reaching. You should turn that down. The most difficult thing in any business is to know when to say no. The same can be true for an employee. And if you do find out that I'm not an employment specialist, but if you do find out that there is something completely unacceptable that your employer is doing, and that you now feel that your position within the company to remain is untenable, and you are forced to resign, those are the startings of the elements of an unfair dismissal claim, where you have felt that you have no choice but to resign because of the way the company's treated you. And therefore you lodge your grievances, and if necessary, resign, and if necessary, file complaints and claims for unfair dismissal, for which, of course, you should seek formal legal advice. But on the face of it, in my view, there's very, very little to justify keystroke loggers. Even if you're, let's say, a programmer, a coder, technician, or whatever. I know from my days of doing software development that the commit, which is what we call it when you've done a new piece of code or amended code and you commit that to the repository, you update the software server with your code changes, those commits will be able to track the progress or lack thereof. I've hired developers before now and had to keep track or lack of the development that's been done, and had to say, there's only been one commit, this month or whatever, and it's just unacceptable because it's a low level of work. Those are the ways that employers should be tracking work, not with a keystroke logger. So if you're a company, take this as a warning that you need to do an overhaul and check all the practices for your data protection. And if you're an employee, then you need to check your contract, check what your employer is doing. Did I say employee twice? I mean employer the first time, I'm not sure. But yeah, check those things out. Make sure that your company is not overstepping the bounds. And if you are interested in general data protection with regard to filming, whether that's in court or whether that's out in public, the general position is out in public. If you want to film, other people have no automatic right to privacy, but there's been huge debates over on Twitter about whether there's a reasonable expectation of privacy. Court of Appeal has found on a number of occasions that someone can have a reasonable expectation of privacy in a public place, even though it's a public place and you've got no automatic right to that. But the circumstances will dictate the extent of the information, the age of the people, the particular circumstances that they are caught. The discussion that I had was to do with emergency services workers. I did a video on it not too long ago. In my view, if it is invading the personal dignity of a person and even the workers that are working on an emergency scene, there should be a reasonable expectation of privacy there. Certainly from the perspective of the news companies that might be filming, but there might also be, if someone captures personally identifiable information, which includes your face, by the way. Somebody made a ridiculous comment to say your face is not enough to identify you. Of course it is. Any information that taken by itself or together with any other information that can identify you is personal data for the purposes of the Data Protection Act. Ergo, your face is personal data. I would hope that goes without saying, but some people disagree. If you take that information and people spread that online, it could be the misuse of personal information, even though it was in a public place. Every case will turn on its own facts, and mark my words, when some of these go to court, because eventually some of these situations will go to court, the court is likely to find, in at least some of those cases, that there's a reasonable expectation of privacy, just like in the case here with employees being tracked, such as this lady here. I hope you found that useful. Please do check these things out. Don't just blindly follow them. And with that, please do like the video. Remember to subscribe. And as always, thank you for watching.